All right. Good evening, everyone, and thank you for taking your time to be with us today for our monthly talks. Today we'll be having Bernard Towe. Bernard Towe is a land expert and also an alumnus of the Oma Bay School. Um, we will not wait anyone, or will not delay the meeting further. Just trying to make some individuals. All right. Thank you. So Towe is also a member of the board of management for the Oma Bay National School. Has a master's in real estates from the Royal Institute of Technology in Sweden, and also a Bachelor of Arts degree in lands economics from the University of Nairobi, and has over 20 years experience in land and property management. Without wasting much time, I'd just like to welcome our speaker of the day to take over. Yeah.
Thank you so much, comrades. Good evening.
Good evening.
Let me just share my screen so that we can quickly go through the discussion. So I was asked to talk about a few issues regarding land, but they are quite wide topics. So what I've done is to do a very quick summary. So hopefully I'll be able to give a good picture or make a good attempt at this presentation because the areas are quite wide. But I'm going to try to attempt a very quick, precise summary of all the items on this presentation. So we'll quickly, the issues we're going to look at basically include buying and selling of land, land tax in Kenya, land rent, a distinction between those two because there's a bit of confusion right now with the very many amendments that are happening, particularly the two laws that were signed by the president the day Raila passed away. Then we have land succession, and then we have adverse possession. And if time allows, we'll talk about compulsory acquisition and land disputes and conflict resolution. So basically land, I don't want to take it for granted that we all know what land is, but the Constitution says that the Constitution actually gives a definition of land to mean land as we know it, that is the soil plus minerals plus water bodies plus nature reserves and wild and national parks. Basically, the Constitution gives a categorization of land, not really a definition, but there's a definition in law which I don't think is relevant for our purposes here. Then we have land tenure. Land tenure is basically the way people access, control land. So basically, how you access it, how you control it, how you use it. So for example, we talk about a freehold. Freehold is a tenure type that gives you absolute power to own land. There's no time limit. Then we have leasehold. Leasehold, now there's time. So the difference between freehold and leasehold is on the limitation of time. So what leases have definite time periods, and freeholds do not have a time limit. Now, leases in Kenya can go for a maximum of 99 years under the current constitution. So that means that the leases that the old leases that are going for 999 years automatically have been reduced to 99 years. So that's the highest in terms of robustness or width of the right. It can only go as far as 99 years. Then we have land rating or rates. I'll talk about this later on, but land rates are tax. They are a form of land tax that we pay to the county governments, or formerly municipal, the city council, municipal or town councils. So those rates that we pay, they're called rates. That is a form of land tax, and is a revenue generating opportunity for county governments. Then land rent is just rent. It's not a tax. It means that you're using the government land as a leaseholder. So you're supposed to be paying the government rent on the land that they have. So those two rates are taxes. Land rent is just rent. It's not a tax. Then land conflict, of course, goes without saying. There's a major disagreement. It could be a disagreement about ownership, a disagreement about boundary, a disagreement about title, a disagreement about maybe encroachment. So that is sort of disagreement we call them disputes or conflicts within land. Then we have adverse possession, which is simply a legal doctrine that allows one to claim ownership of somebody else's land after you stayed on it for a period of not less than 12 years. We'll see that in detail later on. Then compulsory acquisition is the power that allows the government to take land by force, to take land by force for the construction of, for example, major infrastructure projects, or let's say for public good, for any use that is for public good or peace. The government has the power to compulsorily acquire land. So quickly, when you're buying or selling land, there are two parties here. We have the buyer, and then we have the seller. For the buyer, you'd be expected to conduct due diligence, of course, do a search from the SASA platform or at the local land registry, because not all titles in the country are already on SASA. Most titles in Nairobi are already on SASA, but throughout the country, it's still manual land searches. Then, of course, you can engage a lawyer. If there are issues with boundary, you can engage a surveyor. If you have issues of wanting to know the market value as a buyer, you can also engage a valuer. Okay. Then, of course, you negotiate on the price, the normal process, you negotiate on the exchange amount, and then the lawyer drafts a sale agreement, and then you typically pay a deposit of 10 to 20%. So after payment of the deposit, the process of titling begins. So it enables you to, the period between payment of the deposit and the final payment enables the parties to conclude the transaction. Okay. Of course, once the deposit is paid, it's important for the buyer to provide closing document, the buyer and the seller. The documents we call closing documents. The attachments that accompany the transfer form to the registrar. So these closing documents it includes KRA PIN, ID copies, passport photos, a duly filled in transfer form. And then we also have the consent, the Land Control Board. I'll talk about the Land Control Board shortly. They give consent for transfer, mostly for agricultural properties. Then the seller, of course, also provides the closing document. We'll have to provide the original title. We'll provide a copy of the ID and a copy of their passport, a copy of their KRA PIN, and passport photos. So the Land Control Board consent, whenever you're buying property in this country, whether you're buying or subdividing. So we have two steps. If you're subdividing land, you need consent. If you are transferring ownership, you also need consent. So if you're doing a subdivision scheme of many parcels, you'll have to pay application twice. You pay application on the subdivision, and then you again pay for another consent on transfer to your name. So when you apply to subdivide your land, you apply for consent, you will have to attach the following documents as indicated on the screen there. Now, once this has been submitted to the Land Control Board, the Land Control Board is chaired by the DCC. The lowest level is at the sub-county level. So the DCC is the chairperson, and then the secretary is the land administration officer. The sub-county county land administration officer. That's the secretary. Then there are members from the county government. There are also members drawn from survey and members drawn from members of the public. So that forms the land control board at the sub-county level. So they give that consent. You pay a regular consent setting is about 3,000. If you want special board, you may have to pay 10,000 shillings. I think it's 15,000 shillings. So that is on subdivision. Then on transfer, once you subdivide and you want to transfer, you do another application for consent. And you attach the following documents. Spousal consent if you're married. If you're widowed, an affidavit, you're swearing in that you're widowed. And during the hearing, the Land Control Board hearing, the spouse must be present. And the landowner, the person selling, must carry the original ID. I'm trying to move very fast. So now that is selling land, transfer of land in the case, subdivision and transfer. Now we quickly look at land taxation, which is a very, I see a lot of mix-up when people talk about it, particularly on the newspapers. Tax is a levy, as you know, is a way the government generates money. So it's a levy, it's a forceful way of generating money through. So I've just listed some of the taxes you may face in this country if you're dealing in land. One is estate tax and inheritance tax. These two are different, but I put them together because they're very related. So estate tax is the tax that is applied on your entire estate that you own. Then inheritance tax is only payable when property is being transmitted or being transmitted to a heir, to a successor. So if, for example, you leave land for children, when they're transferring to their name, that's called inheritance. So they pay tax at that point, which is some not quite high, but some nominal amount. Then we have what we call capital gains tax. This is an income tax, but it is paid, not an income tax, but it is payable when you sell. Like if you buy a property today at 10 million and you sell it in 5 years at 20 million, the capital gain is 10 million. So they apply a rate of 5% or 5 to 10% on that capital gain. So that is payable through KRA. Then we have transfer tax. This is what most of us know. We've encountered this every time we buy land. Transfer tax is stamp duty. Stamp duty. Whenever you're buying land, you pay stamp duty, and generally it's 4% for urban properties and 2% for rural properties. It's the most common form of tax when you're buying property. Then we have severance taxes, which are mostly applicable for resources, natural resources like oil or coal, but they are applicable depending on the amount of that resource that is extracted. So it could be saying 10 barrels, 2%, So so as you do mining and in the extractive industries, as you extract the natural resources, the government taxes every resource that is mined. Then we have land rates, which is tax to the county government. So more about land rates, because this is affecting us, particularly those of us who have plots in our rural trading centers, or even in the big cities such as Mombasa, Kisumu, or Nairobi. So it's a way that the local authority, like the county government, generates money so that they're able to provide services within those trading centers. Services like garbage collection, lighting, security lighting for the roads, the streets, provision of generally the services that the county government provides at the local level. So this is a way for them to generate money. So what happens is that they prepare a valuation roll for every jurisdiction, and the valuation roll will show all the parcels, all the plots, plus the the rate struck amount of tax that is payable on each of those plots. So you are required to be paying rates to the county government every year. Now, of course, the statutory basis is provided for under the Constitution, the County Government Act, and then we have the National Rating Act. That these two have been repealed. The Valuation for Rating Act and the Rating Act have been repealed by this act. So now this is the overriding national law that governs land taxation at the county level. So the question we're having now, which is a very hot debate in Kenya, is whether the government should tax freehold properties. Well, we know that land rates are payable whether it is freehold or leasehold, because land rates you pay land rates so that the county government can provide services. Okay, it doesn't matter. I've heard people saying that with their freehold they should not pay rates. No, rates are taxes that you pay because of the services you enjoy. The question that is generating a lot of debate right now is whether, because the government has proposed to introduce, I don't want to call it rent, because rent will be a misnomer. If you ask a freeholder to pay rent, it's contradictory. It's like you compulsorily taking away land without payment. So I would not want to call it rent, but the national government is proposing to introduce a levy, particularly for freehold properties around urban areas. For example, if you look at Nairobi, we have areas, the suburban areas like Kikuyu Town, Rongai, Kitengela, Syokimau. So the government is proposing that though those areas have freehold titles, they need to pay what they are calling rent, but that is where the legal challenge is, because it cannot be rent. If you're a freeholder, there's no way you can be paying rent. Okay, so that is a challenge. It's a discussion that is ongoing. I don't know how they're going to go about it, but so we need to get ready now for two forms of taxation. One, the one paid by the county government, which is the normal rate, the normally land rate. Then if the proposal by the government succeeds, then we are going to have another levy, which we do not want to call land rent, because for freehold properties, you cannot pay rent. So these ones are just the ways the county governments can assess rent on your plot. The technical issues, I will not go through them unless one has a question that is specifically directed to that. Then if you don't pay, these are some of the things the county government can do for you. They can impose a penalty, they can deny you certain services, they can sue you, they can create a charge on that title, they can also sell that property. Now, the third topic, I think third one, is now land succession. this is a very is a major problem. It's a major problem in this country, and people have lost a lot of money because of land succession. Because the process, one, is costly, and two, it takes a very long time, and then three, sometimes it may require to engage a lawyer. So most of the areas we come from, properties are in the names of maybe our dead grandfathers or the dead relatives. So we are living in land that we don't even have titles to. So that, which means it's very difficult to deal in such parcels because there is no title to transfer. So the transferability is an issue. So I tried to do a summary of how one should go about doing succession. And it depends on, for example, if one dies intestate, that is, if one dies without leaving a will, and if one dies with a will. Now, normally for succession, the starting point is the area chief. So the family members will be expected to sit down and agree, and then the chief will do a letter confirming that the estate of the so and so have the following family members: firstborn son, or maybe wife number one, wife number two, then the children under each house, because the succession is normally done per house. If you're in a polygamous family, it's done per house. So if you have two surviving wives, those will be indicated as the the main characters in the suit. Then their children. So submit a petition to court with details of the deceased surviving family members, supporting documents like death certificate and title deeds. Then if there was no will, you will be there's a process called probate, where you fill in forms to appoint somebody, to appoint an executor to help distribute the estate according to the wishes of the deceased. If there's a will. So if there's a will, it's straightforward. It will just, the executor will distribute the estate according to the will. If there's no will, then the family members will petition for letters of administration, which is a process. It says fill in some forms, and the court will gazette and then declare that so and so is holds the letter of administration. Then after that, you can the court will then issue initial grant after verifying the petition. Then a notice is published for 30 days. This is to enable anybody with an objection to come up, because it enables those who may not be aware that the process is ongoing, they're aware, so that they can raise any objection if there's any. Then the family members will have to agree on an asset distribution. So then wait for objections again. If there are no objections after 30 days, the process moves forward. Then the family will now do what we call they agree on how to distribute the beneficiaries and how the property is to be distributed. For example, if a 10-acre parcel and there are 10 siblings, when you agree on how to distribute, you will say so and so gets this number of acre. If it's 1 acre per sibling, that is the agreement that will proceed now to guide the process of grant. So once that is done, a grant will be issued after 6 months. Then file for confirmation. Then a schedule is attached that shows how the assets will be distributed. Then the court confirms the grant. Confirmation of grant, once it's done, once you receive that confirmation of grant, you can just walk to the registrar's office to apply for a title. Now the next bit here is, I hope I'm still within time. I'm trying to really go through them very fast. I said a dispute or a conflict is the result from a disagreements over many issues. One example that I didn't indicate here, but is dissolution of a marriage. When a couple goes through the divorce process, normally there is a what splitting of the marital property, and that usually leads to a dispute on how properties can be split. The other major common cause of dispute is on boundary. This is very common because people fight even over half a meter encroachment, and in this country we have two surveying systems. We have the general boundary and the fixed boundary. So with the general boundary, you don't expect very exact marks on where properties where property boundaries exist, but they use general features, general geographical features to be able to determine. So neighbors fight over boundaries of a lot, and sometimes this leads to even death and breakup of families. We've seen cases where sons kill their fathers, or even siblings kill each other because of boundary disputes. Then another very common source of conflict is succession. This is common particularly where families don't agree and the deceased did not leave a will. So the families may never agree on how to split that property, and this may drag on. Sometimes it drags on for years. For years, I've seen cases where they are unable to agree. So that means that they can't transfer the properties to their names. Then we have ownership disputes, where we have properties that have multiple owners, maybe 2-3 titles on the same land, resulting from either forgery or corruption. We have cases of green card disappearing from the registries. Then we also have easement disputes. Easements. An easement is a right over someone's property. For example, a right to access. Right to access, for example, the beach. So you find some cases where there are disputes as to how do we get to the river, or how do we get to the beach, to the ocean, or to the lake. We have disputes arising out of such. Or roads. Where do the roads pass? How do we go to our properties? Where do the power lines pass? Where do for urban properties, we're looking at issues of water pipes and even sewer networks, sewer lines. Encroachment. Neighbors sometimes build overlap onto the neighboring plot. So this can lead to a dispute. Then we also have land measurement, where somebody says mine is 1 acre, while the neighbor insists it's 0.8. So a disagreement on the level of the area of the land. Then we have land use conflicts, which is also very common. Land use conflicts common across the country. We have human-wildlife conflicts. Within urban areas, we have cases of users that are juxtaposing, users that are conflicting, like industrial with residential, or nuisances, where users that cause environmental pollution. So these ones are normally very common. Then we have adverse possession, which I'll talk about later. But adverse possession can create a conflict when an individual unlawfully occupies and uses another person's property for a specific period until they claim ownership. Now, how are disputes handled here in Kenya? We have 3 tiers, 3, probably 4. If there's a dispute or a conflict with regards to land, normally we have the informal way where you can just do direct negotiation with the combatants can just sit down and do direct negotiation, talk to each other to try and reach a mutual agreement. Usually this is very good because it's cheap and also it protects relationships. Then you can also involve community leaders. Sometimes the community leaders can help mediate, can facilitate the discussions. And then you can also get a surveyor, not necessarily a government surveyor, but a licensed surveyor who can have, if it's a boundary dispute, you need it's a case of boundary determination. You want to know the extent of your plot. You can agree and get an expert licensed surveyor to help you determine the boundary of your parcel. Then the other tier is alternative dispute resolution. And even before this, there is what we call traditional dispute resolution mechanisms, TDRs, is provided for under the Constitution. The traditional dispute resolution, this one is now a cultural based. For example, if you have cases of pastoralists and farmers, pastoralist communities and farmers conflicting or fighting, this is not a case where you expect them to maybe just sit. Sometimes they have cultural ways of sitting down and doing some cultural rights and solving. So we call them traditional dispute resolution mechanisms. Then we have alternative dispute resolution ADRs. This is also provided for under the Constitution, where you can do conciliation. First of all, the negotiation, conciliation, then mediation, then arbitration, then court annexed mediation. Arbitration is binding, sometimes it's binding, and court annexed mediation is also binding. Negotiation, conciliation, mediation may not be binding, but you can get a third party who is an expert to help with the negotiation. Then finally, we have the formal legal action, which is not advisable, but there are some complex land cases that may have to end up in court. So before we go to court, the court system, because all land cases or disputes are handled at the Environment and Land Court. The Environment and Land Court is a court of the status of a high court. So they're able to listen to all issues related to land and environment. But before the court, we also have statutory bodies, which I have not indicated here. We have statutory bodies that can also handle issues of land. For example, we have the rent restriction tribunal, where that deals with cases of protected tenants. We also have under MCA, we also have a statutory body that deals with a tribunal that deals with the issues of environment nuisance, environmental degradation. Then we also have, like, under compulsory acquisition, there is a land valuation tribunal where cases can go. They are over court status, but they are not within they are not the level of the environment and the level of the high court. They are statutory bodies that deal with land disputes. Even planning, if you agree with the planning issue, physical planning issue, under the Land Use and Physical Planning Act, we have the liaison committees, where you can take an appeal to be considered. So it's sort of a tribunal within. So within each of these land sectors, you find tribunals that handle land cases before you can actually go to court. But now, if you decide to go to court, Here now is the formal process where you go to the Environment Land Court. You may require a lawyer for some complex for the complex land-related cases. Then adverse possession, as I indicated earlier, is one of the most difficult cases to handle. Actually, one of the most difficult cases to win. Somebody claims adverse possession on your land and they can prove that they've lived there for 12 years and you are aware that they were living there for 12 years and you did not give a notice for them to vacate. You did not complain. Mostly it affects lands with absentee landlords. For my brothers who are probably out of the country, sometimes you take 5-10 years before you come back. But probably you're buying land, you're buying vacant lands here. Be checking, put a fence, check if somebody is squatting, do an agreement with them. For example, a case that I know, a guy had workers. He has a ranch. So out of his own good heart, he took 5 acres and put up residential houses for the workers, farm workers. Okay. Now there was no agreement, what was called tenant agreement forms, no rent. So the guy passed away, and when now the surviving family members tried to kick out these workers, they were not able to, and they had to make a title for the portion they are living in. Another case I know is where somebody had put up a pit latrine on a neighbor's plot, whether knowingly or probably knowingly. And that pit latrine was there for 15 years. The owner of the plot did not complain, did not say anything. 15 years later, the owner of the plot demolished the pit latrine. He was taken to court and they lost because that is destruction of property. And the owner of the pit latrine claimed adverse possession. So it's always very important to check out your parcels wherever they are. Ensure if somebody is using it even for squatting or for doing vegetables, ensure you have an agreement. Because if you have an agreement and they are paying you, even if they are not paying you, but you have an agreement, it cannot qualify for adverse possession. The basis or the legal basis or the foundational reason for adverse possession is that land needs to be used. Land should not be left idle. So under that Limitation Act, they're trying to prevent people holding land idle. That is why we have this legal this legal process of acquiring title. So I've said you have to establish, if you want to claim ownership of a parcel of land you've lived in, you have to establish that you have to show that you've stayed there for 12 years, at least. Gather the evidence, provide evidence that it's been in your possession. For example, you've been paying rates, you've built permanent structures, you've been farming on that land. That will demonstrate their intent to own the land. Then you can file a court case. Then the court will determine whether you have a case. Now, the NLC process, this I will very quickly go through because it's, I think, just give me another 5 minutes and I'm done. This touches on, I think, was it early this year or last year that we had, no, it is this year. We had the case of the national government creating a road on part of a high school land. And it raised a lot of debate. generally, the government acquires land through the National Land Commission. However, this is set to change because on the 15th of October, very early in the morning, the President signed the National Land Commission Amendment Act. And this act, in our literal reading, is still something we are discussing within the land sector, takes back the acquisition to the Ministry of Lands. So the Ministry of Lands will be doing the acquisition of land as it used to be before the National Land Commission. So which means what I'm going to give you here may change, may not be the true position, considering that we already have an amendment act assented to by the president. I don't know whether it's been gazetted, but it's been assented to by the president. So usually when you want to acquire property, the CS or the CEC for county government writes to the National Land Commission and provides a schedule of properties they want to acquire, land acquisition map, resettlement action plan, environmental and social impact assessment report, and then confirms availability of fund. Then NLC will move in to do the acquisition process. Now, for our case of our football, our is it called hockey? Our hockey pitch. The question was if land is already public, because Homa Bay High School is a purely government. It's not even sponsored by a church. It's a government school. So that means the land is public. And public land belongs to the people of Kenya, but the agent of the people of Kenya is the government. So the question was, can the government take from his right hand and give to his left hand and pay? Or was this a question of just reorganizing the assets? Because it is still public. It moved from public school under school to public under Kura. So it's still public. There is no change of tenure. It's still in the same tenure regime. Okay. So this is the process. Once the NLC receives the request, they do gazette notice, they sensitize people, public participation, then they will develop evaluation role, and then they do inquiry to disclose to the people how much they're supposed to be paid. And after that, you can reject or accept. If you accept, you are paid. If you reject, you can go now. We have the Land Acquisition Tribunal, which can handle cases of dissent or cases of people not satisfied with the offers given to them by the National Land Commission. So this is an example of a gazette notice. So the gazette notice that the government wants to acquire, gazette notice number, the law under which the acquisition is taking place, title, acquiring body, location, and the public interest in question. If it's a road, that's the public interest. If it is a dam, that's the public interest. If it is for a school, that's the public interest in question. So the public interest must be justifiable. Yeah, then I think that is all. I've tried to go through some, each of these topics can take sessions on their own. So I've tried to very quickly go through them. So unless there's any question, I think I'll end it there.
Oh, all right. Thank you so much, Senior, for that. Before I welcome Nyakwamba to say something before we close, I have some questions on the comment section. Someone is asking, can a will be changed? Can a will be changed? Another question, if your parents died without leaving a will and you do not have the title deed of the land, only the letter of buy agreement, how can you handle that? The other one, what do you do when one encroaches on your portion part of this building or gate being in your portion, and can he or she be forced to demolish? The last question in the comment section is, how is succession done for someone who died without leaving a will? I think it relates with the second question. And he died without leaving a will, and also did not marry or have immediate closest family. The only closest family are the children of his brother, and the brother is also deceased.
Okay, thank you very much. I will attempt to respond to them. A will can be contested in court. It's happening all the time. So if you're able to demonstrate that there's something unfair, because there are some wills that are manipulated at the point of death, or some wills that are clear out forgeries. So if you can demonstrate to a court of law that the will is unfair, or there's a case of forgery, or the court can quash it. Then the second question, it says that they have a sale agreement, but there is no title.
Yeah.
So what will happen? And the seller is dead. The person who sold it is deceased.
Yeah.
So what happens is that this one goes back to succession. The remaining beneficiaries, of the seller, because a sale agreement is just an agreement. It shows that there's an intention to enter into a contract. There's an intention to transfer. But a sale agreement cannot get your title. The titling process is achieved through succession. So the surviving heirs of the deceased need to do the proper succession, get the titles in their name, then sell to you now. So that will be a new agreement. But of course, you have that old agreement, sale agreement, which you can use to take them to court. You can take them to court on the basis of a payment that was done. You understand? You can take the estate of the deceased to court. But if there is an agreement, the surviving heirs can just do succession, get the titles, and then sell to you, or even get title straight onto your name during succession. So you can be included during succession as one of the beneficiaries to the estate of the deceased, so that you get your title alongside the surviving beneficiaries.
All right. Thank you for that. I see their comrades who have raised their hands. We'll start with Billy Otieno. Please make it brief because we are also running out of time. Billy Otieno, then Jared. If they can ask the questions once, and our speaker will note them so that he can respond to them once. So Billy, you'll go first, then Jared will follow, then Alois Kennedy, and then Duncan Okech. Please, Billy.
Okay, thank you so much. I got a question relating to land. I'm one of the victims who have been affected by the Koru Soin Dam. I'm coming all along from Moroni Koru. So it had been gazetted some times back that there will be a construction of a Koru Soin Dam. Unfortunately, half of those people who ought to have been evacuated from that place were compensated, but again, half were not compensated based on the government, government arrangements. The only challenge that we have, I'm a victim of those people who the government didn't come into compensation, or in one way or the other, they didn't come through to get them compensated because of technicalities that they do have. However, I am coming from a family that had the challenge of the same land succession. You see, the government can only compensate a person who is having a title deed showing the ownership of the land. Unfortunately, the family that I come from, now that it is a polygamous family, they do not have the title deed. Is the government willing, or will that case be of not being compensated because we do not have the title deed, or there is a way that we can reclaim that we also ought to be compensated just like any other person without the title deed, now that we have stayed there for more than, let's say, 40 years? How are we going to do about that? Thank you.
All right. Thank you. The next person in line.
Thank you very much, colleagues. I also have a question. There is a case of some land that a friend of mine bought, and it's bordering the lake. So what he did was to buy the upper portion, and then somebody else bought the lower portion bordering the lake. Now, this person who bought the lower portion bordering the lake do not have access. And the one on the upper, now, of course, there is a road that borders that one. So there was a tussle on the lower person saying, I need a road. I need to access my piece of land. And so the upper person, the one who bought the upper person, was saying, no, I cannot give you access because I also bought this piece of land. So if you want access, then you will have to buy from me a road going to your piece down here. So this person did not. Finally, they got into a gentleman's agreement, so to say, and together with the help of some community leaders, that the person bordering the lake would access his place using his gate, kind of a footpath going to the lake. Now, it happened that this area, they didn't have titles yet, just the demarcations and, you know, that process of allotment and preparation for titles. So it's like this person bordering the lake became tricky and went to the land's place and inserted a road which is drawn now in the map, passing through the parcel, the upper parcel, without this man's consent. It's like he used the agreement they wrote down with the community leaders. So when he came to realize this, he was shocked. He said, no, I didn't mean a road. I just said access, he would use my gate as he's going down to his place. So he came to ask me, what should I do? And I think I was waiting for this meeting so that I can be informed and educated to help a friend. Thank you.
All right. Thank you so much. For the next people in line, please make your questions brief.
Hello, Mr. Legawa. Please, maybe can you allow Toe to respond to that? Because of time, we only have 5 minutes. So that.
All right. All right, sure.
Yes.
Okay, now the issue of Koru Soin Dam. I see this very many times in the dams that are being put up across the country. What I would suggest you do is check, because most of those areas, I believe that they have adjudication numbers. If there is an adjudication number for the parcel on which you live, I'm responding to Billy's question first. That if you have adjudication numbers, you can go to the land registry and get your title. Most of the times, the title is just waiting to be written. You just need to pay the statutory fees if you have an adjudication number. I believe that area has been adjudicated. People may not have titles, but the area has been adjudicated, because there's no way some people would be having titles and others not. The others who don't have titles have not just gone to the registry to apply for the titling. And I agree with you, the government cannot pay you for land if you don't have the title, but they can pay you for the improvements. They can pay you for the crops, the trees, the houses that you build, but they don't pay you for the land until you sort out that issue of title deed. I hope that answers your question. But if you still need more help, you can even talk to me later about it. Jared, this case is very complicated. The person who bought land along the lake and the person who bought land on the upper part looks to me that like they did informal surveying. They did informal subdivision of land initially at the outset. Then very quickly, the person on the lower side moved ahead with the process, moved it from informal subdivision, went as far as amending the map. So what should have happened in this case is that they needed to have created an easement, because the guy has created that easement without payment. So this guy can actually follow up. The guy on the upper part can follow up for payment to create an easement, because it's already on the map, but there's no evidence of any consideration paid. Because if to create a road, you only need to agree with the owner of the subservient property and the dominant property need to agree to say, I'm giving you this corridor to pass. With that agreement, I just need to go to the registrar or I get a surveyor to amend the map. So I think the guy along the lake named Cora, and he moved very quickly to initiate the process. So I'm very sure the guy on the upper part, if you have the evidence that that was your land area, you can pursue. You can pursue the guy to pay you at least for the easement corridor.
Thank you, Bernard. Because of time, I think we are left with 3 minutes. I would suggest you may give them your contact so that people may contact you directly.
Yeah, if you look at that, the last slide there, I have my number there and my email address. I don't know whether it's visible.
If we can post it on the
yes.
WhatsApp channels. Yeah.
Yeah.
So Ligawa, can you wrap it up?
I don't know if Nyakwamba has something to say so that he can, maybe Nyakwamba, if he has something, he can just finish off the meeting.
No, I don't have something to say. Time is not on our side, but I just want to thank Bernard for such a great presentation. Otherwise, thank you for hosting.
Thank you so much.
All right. Dylan, if you can just close for us, maybe with the announcement concerning the gala and everything, so that we can just call it off.
No, the gala, we will do the announcement. Maybe you just pray and we call it off, please.
All right. Let's believe and pray. Dear everlasting Father, we thank you for this great time, and we thank you for the information and the knowledge that our brother has passed to us. Father Lord, we pray that you'll guide us and you'll put up the spirit of brotherhood in us, and you'll also let your will be done in our lives, O Lord. Father Lord, we pray that you will be with us and you'll grant us a beautiful and a lovely night, O Lord. We pray all this in Jesus' name. We are trusting and believing.
Amen.
Good night. Good night, guys.
Good night.